let's move to the...
Professor, I have
Yes.
a question on the CLA exam for the first certificate.
I've sent an email to everybody.
I read it, but I have another question based on I wrote an email to the CLA and they didn't answer me, but I asked them to put me in the list with the other guy that are not doing the course online but have only to do the exam, and they didn't answer me. So
Well, I suggest you write again to, I think it's Didattica at CLA, and you write also to Ferruccio-Metri. If you don't receive an answer, just write again to me and I'll try to see, because as a matter of fact, I asked last week and I got immediately a reply. So I'm just trying to understand if it's just your mail that hasn't been replied to, or it is a general, dysfunction of the system.
Okay.
So send another mail to Didattica at CLA and to Ferruccio-Metri and see, and keep insisting and inform me if you don't receive an answer.
I'm sorry for stopping the lesson, but I have another little issue to tell you about. Is that we have to do the exam before the June test for our course, or we have to we can even do the exam, I think, in June, but and then we give to the class.
This is something I think that all the rules that were set will somehow have to be adapted to the circumstances. So we shall, I will put this issue, if you can write this question to me, put it in writing, and I will return it to Professor Menzinger and Professor Ginebri, who are the coordinators of the GLS program. And so, because clearly the decision we are taking is valid for everybody. I mean, it's only in this course, but obviously this is a precedent. So I would like them, that are the coordinators, to take the decision. So if you can write me an email, send me an email, and I'll try to, and I'll forward it to them and see what the correct solution is.
Perfect. I'll sending this after this lesson.
Okay, thank you. Then, as I was mentioned, we're going to analyze this week, we're going to analyze the issue of jurisdiction and try to understand how the role of jurisdiction is related to legal systems and how legal systems compare when we look at jurisdiction. Now, let's go. I've prepared some slides. I trust, can you see the slides?
Not yet. Yes, now we can.
Can you see the slides?
Yes.
Okay, that's fine. So, obviously, jurisdiction is an easy word for those who have studied Latin, jus dicere. That means pronouncing the law, saying the law. And if we want to give a very broad definition of jurisdiction, we can say that it is the authority which is granted to a body to administer justice within a defined field of responsibility. This is important because we shall see that in each legal system, there are many jurisdictions. There's not only one jurisdiction. The jurisdiction, we use jurisdiction in two ways. When we refer to a legal system to a country, in sort of, we say Germany, in the German jurisdiction. So what the decisions taken in Germany are, the legal system is. But at the same time, when we look at the country, we shall see that jurisdiction, that is the power, the authority to pronounce the law, can be organized in various ways, and we shall see how it is organized. So This is the first notion. The second notion is that I would like to point out that the notion of jurisdiction is intrinsically related to the notion of justice in the Western legal tradition. For us, and this makes a great difference between us Westerners and other cultures, which doesn't mean they're simply different. It doesn't mean that they're up or down. It's quite irrelevant. This is not the issue. It's that simply they're different. Our idea of justice is something essential in the idea of a legal system. The law cannot be without justice. A law without justice is not a legal system. We use the Latin expression summum ius summa iuria, that is great importance, that is the maximum of the law, but also the maximum of injustice. So what we do in the Western legal tradition, we always keep together the law and justice together. At least this is the aspiration, not that we always manage, and quite often we do not manage, but this is the ideological, the ideal of a legal system in the Western tradition. And so when we talk of justice, we mean that there is some kind of judge. I mean, obviously there's the justice, the divine justice that is religious, whether it is the gods who decide or the divinity, and that is something to do with religion, but mostly we are talking about justice which is administered by the power. The king mostly is administers the justice and is the judge. If you go back, those who want to, who like classical readings, go back to the Greek tragedies and in many, Antigonus for one example, you will see the role of judges and justice in Greek tragedies. Just to point out that these are not simply literary references, not cultural references, but show you where the roots of the idea of how law and justice are tied together in the Western legal tradition. We cannot do one without another. So we always think that there's a law, generally a written law, and at the same time there's someone who must pronounce the law, and that is the notion of justice. So this is the first starting point. And so if we have to say that, generally speaking, traditionally, jurisdiction has to do with the role of judges, we have to see who these judges are and how they are selected. Just to point out, if we look at it from if you want, not from a legal point of view, if we were some anthropologist that suddenly is coming from Mars, from Venus, and sometimes and comes down on the Earth and tries to see how disputes are solved, obviously he would, this anthropologist would go, let's imagine, goes in a court and looks at judges, but might go in a football pitch and see who decides conflicts between the two teams and looks at the referee in the football match. Now they both decide whether it is a judge in a court or a referee in the football match. They both decide conflicts. Well, obviously the referee decides in a very swift way if to give a penalty or not, but they decide. But obviously, and they work on rules. Obviously, if you think of it, football match has a whole lot of 17 rules which are valid all around the world, and have been set out more or less in the 19th century and are still there with a little bit of changes, but not much. But the problem is who decides. Obviously, if it is a judge in a court, or a referee in the football match, the decision might be quite different. So we are interested in understanding who the judge is, the judge, quote unquote, who is the person who decides this conflict. Because according to the person who decides the conflict, the decision might be different, and especially the, the rules that this person will use to decide the case, procedural rules will be different. So let's return to the traditional aspect, so judges. So we have more or less in the Western legal tradition, we have the idea of who a judge is. Someone who sits in a court and has the authority to decide conflicts. But it is very important to notice that we have two models in selecting judges. Why we're interested? Because obviously the way you select the judges has a very profound influence on the system. And often when we look at systems, you're convinced, especially if you when you start your legal studies, you think that your system is the only system, while we see that there are different systems, and these different systems give a different taste, a different flavor, and a different way through which these systems work. So let's look at what we know, most of those of the class who are in continental European systems. Well, obviously then we have, I think, this wood online, so obviously then we will move to England. But let's look at the continental European system, which is somehow familiar to most of the class, even first-year students. So what is the idea? That judges, and I'm looking at judges, those who decide a case, are high public officials. So they're civil servants. They belong to the administration. So this is the first element. So they are public officials selected on the basis of a public and competitive examination, aiming at ascertaining their knowledge of the law. So students graduate from a law school, whether it is in Vienna or in Copenhagen, whether it is in Madrid or in Bucharest or in Nicosia, Cyprus. Well, they sort of, if they feel that this could be their job they would like to do, this is the profession they would like to follow, they have a vocation, and they participate in a public and competitive examination. Generally speaking, there are sort of 10, 100, 300 posts vacant according to the size of the country, and the graduates participate, and those the best who succeed best in the exam enter the public administration. Now, this is something that is quite common for other branches of the administration. The idea that you enter into public administration through a selection, a public selection. And so judges, at the beginning of their career, the selection is more or less similar to what you could find in other branches, whether it is for diplomats, for the military, for the police. Well, you would see that this is more or less the system you use in continental Europe to hire public officials. So this is those who are selected and enter the judicial organization. They have a hierarchy and that means that there's an order by which pyramid in which someone enters at the very bottom of the pyramid, and slowly through the years will probably go up this pyramid and rise to a higher level. So this is the first point I wanted to make. And then, let's see if yes. And obviously the system is a system of promotion. If you do your job properly and according to, and you have you have a good proficiency, you do what you have to do, and your decisions are not constantly quashed, because obviously that means you have decided wrongly. Well, what will happen that the judge will will be promoted from a peripheral tribunal, a very local tribunal, to a less peripheral court, and then to central higher courts. So it is a system which is typical of very much of public administration in continental Europe. The further element I wanted to point out is that judges are public officials. They are selected in this way that we have seen common to most public administration, and progressively throughout the time, and especially after World War II, with the post-war constitutions, there are constitutional guarantees of independence. So judges cannot be moved or removed. So the idea that their independence is protected, the government, they are selected through, they are public officials, but while public officials may be somehow moved from one office to another, and they have to follow what their indications of their, let's imagine a minister, an official, someone who works in a Ministry of Agriculture or a Ministry of Defense can be moved around according to what the needs are. In the notion of generally what happens in continental Europe, the judges are independent and cannot be moved or removed. That is to ensure independence. So you don't have to, when you take this decision, that decision does not influence your career. It isn't that you take a decision which is not, that the government does not like, and you are moved hundreds of kilometers away from your hometown, somehow being punished because you've taken a decision which it hasn't, which the government does not agree with. So this is the idea, the structure of the tradition. So it is quite common that that there are bright people who come from who have a law degree and then enter this profession and generally remain in this profession. It is what is quite common in the continental European tradition, is that once you've entered this profession, judicial profession, you remain there for most of your life. Then obviously some people will change their profession, but it is a limited amount. Generally, it is like what generally happens in public administration. People enter public administration and remain there. Now, this model is completely different from the English model. So this is very important, because when we start comparing models, we want to, what maybe seems strange, it is we only have the channel between sort of continental Europe and the British Isles, but you see a very different model. And so we try to understand if these differences, which are striking differences, are changed substantially the legal system or not. This is what, when we compare legal systems, we are interested in understanding. So what happens is that since the Middle Ages, and the Middle Ages means, well, 13th century, so it's pretty way back. It's sort of, it's not sort of late Middle Ages, already sort of 13th century, starts really in the 13th century. The judges are, yes, they are designated by the king. It's the king that designates someone as a judge, but not the king doesn't choose anybody as a judge, doesn't select people who he trusts, but progressively the the king designates as judges practicing lawyers. We shall see this later on, barristers. Now we should look at later on the, sort of the legal profession, which is an important aspect of a legal system. Barristers who have a great repute among their peers. That is that the most lawyers who practice in lawyers who are considered among other lawyers, among their community, being able, knowledgeable, and balanced. This is a very important aspect because you obviously want someone who, in deciding, has a balanced view of the position of the different parties. These people are indicated by the barristers, by the group of the barristers, are indicated to the king and indicated as judges. This is the tradition. So, as you see, it is not sort of surely it is a public function, but they're not sort of traditionally public officials. They are, instead, they come from a liberal profession, that is, of practicing lawyers, and then turn into judges. Now, this is very important from a sociological point of view, from a psychological point of view, because you understand very clearly that the judge is someone that until the day before was eating with all the rest of his community of practicing lawyers, and then from one moment to another moves from the bar, which is where the barristers, the indication is not where you drink, but the barristers work. Maybe we can discuss this notion of bar, which is literally a bar which separated the court from the public, and the bench where the judge sits. So you see that the barrister, one day he is a barrister, and the next day, or anyhow, not after some time, he may become, go on the bench, sitting on the bench and being a judge. So you see that also the kind of people that turn into, that are judges, come from that tradition, that of barristers. So it is pretty interesting to see how this creates a certain identity of the judges, and also it is a tradition that lasts, as you can see, it has been lasting for over 8 centuries. So it is a very, very long tradition embedded in the idea of the English system. The judges, the English judges, are independent in the sense that they are designated by the crown, but they are traditionally separated from the crown. They are designated, it is the king, the queen now that designates the judges, but there's no doubt that they are completely independent from the queen. It isn't that the queen, the government, whoever it is, can call the judge and say, well, you take this decision, or would you mind being very careful in taking this decision. So it is very clear that the notion of independence is embedded with the idea, is intrinsic with the idea of English judges. And historically, English judges have often sort of had sided more with Parliament than with the crown. So we see historically, especially in the troubled 17th century, that the courts, the English courts, were on the sided with Parliament against the king. So just to point out that this is, as you see, a very different aspect, and we shall look at this also when we look at legal education. We'll see this later on in a further lesson. This also legal education, how you become a lawyer, is well, it is a distinctive element of legal systems. Now let's see In the American model, now this is important because clearly the English model is exported to the US, but and we find some aspects which are common between the American model and the English model, but the problem is that the constitutional system, the American constitutional system, is significantly different. So this changes a lot in the role of judges and how judges are appointed. So first element, if you remember Article 2 of the US Constitution, it says that the president appoints federal judges. So it is the prerogative of the US president to appoint judges with advice and consent of the Senate. Now, clearly this hypothetically could have a certain amount of problems because this means that the president chooses, and that and if the Senate is in favor of the president, well, generally the designations will be accepted. This is, to a certain extent, is true, but at the same time, it is rather unlikely that the people will receive, the president will not designate anybody, but has to designate people who are qualified for the job and have all the qualification. Otherwise, this person will be immediately somehow be disqualified. They will not be considered as qualified judges. If you remember, when we analyzed the Marbury versus Madison case, it was actually, the point was not of the qualification of Mr. Marbury, who was perfectly qualified for the job, but the problem was that Madison did not like his predecessor to have designated midnight judges. So so it's the president's prerogative in the US to designate the judges, but and this is the federal level, then we have, remember that the US has this dual system, a federal level and a state level, and we see that in several states, judges are elected on a party basis. If you look at the states, they're important. It's Alabama, Illinois, New Mexico, North Carolina, Pennsylvania, Texas. So these are important states, and they are judges are presented, are Democrat or Republican judges, and so depending on what the sort of tendency in those states are, maybe we might have more judges who are more supportive, more leaning towards Democratic points of view, or Republican points of view. And there are, and I haven't listed them, a whole lot of other countries where, states, sorry, are US states, where judges are still elected, but they are elected on a non-partisan basis. That is, they do not run under the Democrat, in a Democrat list or in a Republican list, but in a general list. So, but anyhow, we see it quite common that in many states in the US, quite a big number, judges are elected, which gives you the idea of the notion of we the people. So the idea that judges that are sitting there have been elected. But we must also look at this other aspect, which we have incidentally seen when we were looking at criminal law. We have to consider that when it comes to criminal matters, we have not only obviously a judge, but we have a public prosecution. And in the US, what do we have? We have federal prosecutors, that is the Attorney General, which is the head of the federal prosecutors, who is designated by the president. And there have been various changes in the law, but the most recent system from 2006 onwards is that the Attorney General designates district attorneys. So we see that generally the public prosecution from a federal point of view throughout the US somehow depends from the, let's say, from government, from the executive, because the executive designates the president, attorney general, and the attorney general then designates the district attorneys. Obviously, there are many people, there are sort of thousands of federal district attorneys that work in the district attorney's office, but they're just hired on a basis for a certain number of years and are working as in the district attorney's office, while the head of, let's say, district attorney of New York rather than Texas or Florida, from federal district attorney, is designated by the Attorney General of the U.S. So this is the U.S. system. While at a state level, generally, we see that state prosecutors are generally elected. So the head of the public prosecution in Mississippi or New York or California, generally speaking, they are elected. They run for election. So this is interesting to show that this idea that democracy, that justice is administered in the according to the will of the people. You find it not only in the court because there is the jury, but also in the prosecution. So prosecutors are somehow must follow what indications of those who have elected it. If they are we imagine that there's a public prosecutor who has been elected on Democrat ballot, well, obviously be more careful to certain kind of crimes, and a Republican maybe to other kinds of crimes which feels he or she feels it's more important. Then further elements. So just to point out that the way through which you select judges, and in the case of the U.S. also public prosecutors, is not irrelevant in making the legal system, in shaping the legal system. Then there's a further element. The territorial distribution of the courts. Now this might seem irrelevant, while instead it's very significant from certain aspects. We have seen that in the continental European system, the territorial organization of the courts is more or less that of the administrative geographical partitions. That is, that the country is divided in regions, and each region has a court, maybe has a small court, and then has a central court in that region, and then there's a central court in the capital. So we have local courts, intermediate appellate courts, and then higher central courts. So this is typical system of organization of the state that we have found, let's say again, the starting point is obviously the Prussian kingdom or the Austrian Empire, and then is transferred to Napoleonic France. So this is the idea of you divide a country in regions, you control these regions, each of these regions has courts, and then there's this pyramid that reaches to the capital. Now this is the continental European model. Instead, the English model is significantly different. Why? Because historically, and still now, the courts and judges are concentrated in London. Just to remind you that there was this medieval tradition, medieval, and he meant all around Europe. The king really, well, he did have a capital, but moved around the country because he wanted to show that he was the king. And he was moving around with his judges, with his court. Or rather, he went to a place and he listened to the cases that were and handed the cases to his judges. So they were somehow moving about. The court was moving about. And this was quite common in most kingdoms of quite a big size, that the king moved around his kingdom with his court. You will find, if you're interested in the notion of in medieval history, assizes. Write this down. 1 second, if I can find it. Sorry. Trying to look, yes, here we are. Write it here. Sorry. Sometimes So this is the idea. The king went around with his court, and where he went, he decided the cases. In the Magna Carta, in paragraph 17, as you see, ordinary lawsuits shall not follow the royal court around, which should be held in a fixed place. And this fixed place is London. So what we see is that traditionally, and the court, the English courts have developed in, if you go to London and you look at, well, now they're in Strand, but in a very small surroundings where the courts were, the inns of court, that is where the lawyers were working, was a very limited area where all the judges and the lawyers were together working all day long. So everything is concentrated in London, and we have county courts, so somehow some local decentralization only at the beginning of the 19th century at a very low level. We still find in England, obviously, there is decentralization. The main cases are all decided in London, while in the rest of Europe, we see that obviously cases can be decided in a local court, and then they go, in appeal, they go to a bigger town, and then they will go central to the capital. While historically, that means for the last 8, if not more centuries, 9 centuries, cases have always been decided by in London. So this means something, it means a lot, and this gives to the English legal system a flavor, a substance that is very, very different from other legal systems which have been somehow been dispersed and have been sort of where administration of justice has been given in various parts of the country, and only at a certain point they are joined together at a higher court. Now, a further element that I would like to attract your attention on when we're looking at jurisdiction, and we're looking at how many sort of who administers justice from traditional forms, well, just look at these numbers I've tried to put out. Germany, we see that there are 20,000 judges, which is the highest number in Europe. Germany is also biggest country from number of population of Europe, but you see 24 judges for each 100,000 inhabitants. So that is the highest level that you find in Europe. France and Italy are more or less the same, 7,000. We exclude public prosecutors. We put that aside, we'll discuss that later. And that is 10, 11 for 100,000 inhabitants. Spain, you see more or less the same, 12 judges every 10,000 inhabitants. Then you look at the US, well, sorry, the UK, we find it's 2,000, which is only 3 for 100,000 inhabitants. So what does this mean? Does it mean that in England there are very few cases and you can have less, you need less judges? Well, we will see that this is not exactly the case. We will see that other forms of administration of justice. In the US, we see that you have 1,700 federal judges, which is a very low level, as you can see, for federal controversies. But please remember that according to Article 1, Section 7 of the and 8 of the US Constitution, the federal competences are limited, and then you have about 30,000 state judges, which is more or less 9 judges every 100,000 inhabitants. Just to point out the numbers, because when we look at the judicial order, we're going to try to understand how the judicial order is organized. Well, obviously, if you have to organize 20,000 judges or 7,000 judges is one point. If you have to organize 2,000, well, it's something different. Just to point out that this is, the number of judges is also very important when we look at jurisdiction. This has to do with, obviously, with sociology, with statistics, but also with public funding. Who pays the judges, and what is their position, their legal position from the career, their career, how much they get paid, what if they have promotions, and so on. So this is also an aspect we must consider when we're looking at jurisdiction. However, I would like to point out that this, first of all, that, and this is what we see in England, but not only in England. We see that increasingly, historically increasingly, we find that cases are decided by non-judges, or we say they are formally judges, but they're not professional judges, not people who are doing only that business. So if we look at England, which has the same amount of population as France and Italy, why do we find 2,000, only 2,007, yes, more or less 2,000 judges? Because most of the activity, of the judicial activity outside London, county courts, for example, the decisions are taken not by professional judges, but by people who are often lawyers and who are at the same time, they are doing a practice, they are practicing lawyers, but at the same time they decide cases. So this is very important. So we find what we called, just let me, put this here so I can. So there are lay judges, which are not professional judges, but justices of the peace, or they have other names, honorary judges, and that are not professional, not full-time judges, and therefore we do not list them in that numbers that I pointed out before. are not considered as professional judges, but they have a very important role in the administration of justice and in jurisdiction. But this points out that then we have, as you see, different kinds of judges, people who decide, who have the authority to decide cases. In these circumstances, lay judges have the authority, but they're not part of the judicial order. Then we find, not only do we find a considerable amount of laymen and laywomen that are involved in jurisdictional activities, but we find also courts which are places where you decide cases which are not the traditional courts. When you think of a court, you think of a judge, a former professional judge, and lawyers that follow certain rules. But we find an increasing amount of fora, of places where cases are decided, which are not traditional tribunals. We find, for example, labor disputes. And so there's a labor dispute between the employee and the employer, and these, sometimes they're brought to court, sometimes they're decided, in many countries, decided by special commissions, parajudicial institutions, in somehow not to bring the cases to court. So this is, and as a considerable amount of labor disputes, well, this is one of the ways through which conflicts are, industrial relation conflicts are solved. And then think of landlord-tenant disputes. Again, very common dispute where you, instead of bringing the case to court, you have it decided by, in some other forum where there are people who are designated. Just imagine one court has 3 members. One is designated by the Association of the Landlords, another is designated by the Association of Tenants, and the third is independent. And this decision is taken therefore outside, not in front of the traditional court. Then we have consumer controversies. Again, enormous amount of consumer controversies, which are very small controversies. Just think of someone who is challenging the bill, the telephone, the mobile telephone bill, or the internet connection bill for 25 euros, and well, you wouldn't go to court for that, but you have other ways to solve these kinds of this. Then you find, and we've seen that when we were looking at public administration, we have this role of administration that is quasi-judicial. In many cases, when there's a conflict, this conflict is somehow solved within the administration. The administration has somebody which is there to solve these conflicts. So what comes out, and then we have obviously arbitration, and which means that the parties decide that they are going to their conflict is going to be solved by an arbitration tribunal. This means that there's a contract in which the parties have voluntarily decided that any conflict that arises, any claim that arises among the parties, will be settled out of court. So this is very important because it gives us an idea that until, let's say, 40, 50 years ago, we had a very especially in the Continental European system, we had a very state-centered idea of jurisdiction. So jurisdiction is courts, state courts, official courts, professional judges. Here we see that gradually this notion of jurisdiction tends to somehow be sort of eroded, reduced by a whole lot of other ways of solving disputes. Clearly, this has to do, when we want to classify this, we would say probably all these labor dispute commissions, landlord-tenant disputes, and so on, are not really jurisdiction. But if we look at how a legal system works, these non-judicial ways of solving controversies are part of the legal system. So what happens is that this growing idea of series of mediation and alternative dispute resolution. Mediation in the sense that you must try to reduce conflicts. So how you try to reduce conflicts, just let's imagine husband and wife who are fighting over the custody of their child. They have a child, small child, 4 years old, 8 years old, and they are fighting on who should have the custody. So is this something to bring in front of court, or should there be some form of mediation, somehow find some way through which the parties are mediated and are brought to reason and find what is the best solution, not only in their interest, but in the interest also, the best interest of the child. So this is just gives you the idea of mediation as one form of dispute, of solving disputes. And then growingly we have this alternative dispute resolution, ADR, in which in a whole lot of areas, we, especially when it comes to consumers or people who have users of services, think of public services, think of people who are using transport services, utilities, electricity, energy, and so on. There's a conflict between someone who is using the electricity and has a contract with electricity, energy, utility, and there's a contrast on how much they bill that this person should pay, and the way how you solve these kinds of conflicts, or conflicts between investors, individual investors, and banks. So someone has put the money in a bank and feels it has been defrauded by the bank, or one has a credit card and there's been an abuse, some third party has abused of their credit card, and therefore there's a conflict with the financial institution. Just to point out the enormous amount of areas where gradually what the whole idea is that of moving conflicts outside the traditional courts, and bringing them in front of other boards, commissions, fora that are meant there, where people who are not professional judges and are meant to somehow solve conflicts. So we see that this is also one of the points that must be made. If we look at jurisdiction in the 21st century, and we try comparing the various models, this idea, and this is very common in Europe, the idea that a conflict resolution is not the exercise of power, that is the traditional. The king went around with his and solved conflicts. And so wherever the king went, his subjects brought the case in front of him, and he had to decide this case, rather pass the case over to his counselors. So the exercise of justice, because the king is enlightened, has been enlightened by God, and has been designated by God, and therefore that is divine, somehow divine justice. No, the whole idea is that the conflict resolution is as part of the public services that are offered to the community, just like health and education. So you expect that, just as you expect that the public administration, the state, should provide you health services, educational services, transport services, well, also judicial services or conflict resolution services. So this changes significantly the whole idea of jurisdiction and of justice, because we think in our contemporary societies that this is a service and it is not something that has to do with power, just like police or the military. Well, we think that we could have, just as we have private police that protects a bank or protects private premises, well, we could have some kind of private justice. And this is the whole idea of privatization of justice, arbitration, alternative dispute resolution. So the fact that justice is no longer something expression of the state, it is clearly authorized by the state. The state does not renounce to its monopoly over the administration of justice, but says, well, I can agree that justice can be, conflicts can be solved in a certain way outside the courts. And here we have, because it comes down always, we always return to this aspect, to constitutional limitation. We find that many constitutions, post World War II constitutions, Italian and German constitution first of all, and then all those constitutions which have followed that line, that means dozens of constitutions throughout Europe, and not only Europe, the principle that citizens have the right to go in front of the court. So however you want to privatize justice and you want to say, well, certain conflicts will be decided through arbitration or through alternative dispute resolution, they must be at a certain point the possibility for citizens to go in front of a court that is a court which is a full-fledged court, a court where there's a professional judge and where there's ordinary rules that apply. So just to point out that this has to do very much with this issue of access to justice and what we mean by access to justice. If this is a fundamental right, and we see that this ends up by being a fundamental constitutional right, that to have a case decided by a court, by a state court. So just to point out that this is a very important issue, and it is growing throughout the years. It has grown and grown and grown, and we see that increasingly there's an increasing demand for justice, and the state obviously finds it difficult to provide justice for all, and therefore is trying to limit access to courts, because this means if you have many cases that are brought to court, this means slowing up the judicial service, because you cannot have so many judges to decide cases. And so just to point out that this is a very delicate issue, because we have on the one hand constitutional right, the constitutional right to access justice, and on the other hand you have efficiency of the judicial system. If everybody wants to go to court, even for petty controversies, that means blocking the judicial mechanism, and means justice for nobody. It means you say if justice is for all and everybody can go to court for anything that happens, well, this clearly means limiting that kind of service, which is a service that costs, and it is not unlimited. It cannot be provided to everybody. It can be provided only to a certain extent, and then it doesn't work any longer. So just to point out that this is something that is very relevant, not only in Italy, but in other European countries. We find this issue of function, how the judicial system works, and to what extent it is sort of fact that anybody can go to court is well, should be somehow, if not limited, there should be some hurdles. The fact that first you must do mediation or some alternative dispute resolution, and then only afterwards you can go to court. Now, these are the first part of the today's lesson. I just wanted to ask if there are questions on this first part. Oh, access to Zribi is asking access to justice. Now, this is interesting. The notion of access to justice is comes from it's a term that has been created by a very important Italian professor who spent most of his life in the U.S. teaching in California. Mauro Cappelletti, who was the most prominent of the pupils of Piero Calamandrei, one of the fathers of the Italian Constitution. And Mauro Cappelletti, who, I mean, he spent most of his time in the U.S. and had a very important role in sort of shaping this idea of access to justice. So access to justice as a fundamental right. They cannot be a country, you are not a citizen if you are not able to access justice. Now, what are the difficulties in accessing justice? There are obviously cultural difficulties because you are not you're not able, you don't understand if you have rights. If you don't know you have rights, you won't go, you don't think you can go to court. And yeah, so that's the first element. So it's education, civic education, you must know you have rights. Secondly, the fact that you have cost. Going to court means something that can be very expensive. And obviously, if there are high costs, then you tend to say, well, why should I go to court? It's a risk, I don't have the money. And so this means that those who are economically and socially sort of marginated, well, they will not go to court. And therefore, even if in the Constitution or somewhere else, they are sort of, you have this right to go to court, you will not exercise this right because it is too expensive. So just to point out that this, so Mauro Cappelletti developed this in the 70s, so this is practically nearly 50 years ago, this idea of access to justice. And how do you favor access to justice? So there's all this movement. It obviously depends on the system because the US system is very money oriented. So you have to find people who are going to do this pro bono, or as they say in the US, that they need to do it without expenses. So you must find associations who are going to defend rights. Just think of typical cases. You find them in the US, but you find them also in Italy and other European countries. Immigrants who arrived in the US or in Europe and are asking for asylum or asking for refugee rights, or they're asking for immigration rights, but they maybe don't speak the language. They have low education, and obviously they have no money, because if they had money, they would have remained in their own country. So then you need someone that helps them to have their rights affirmed in court. So just to point out, it depends, this idea of access to justice as organizing a very a system by which you can have your rights recognized, not necessarily going to court, also through alternative means. And this is the whole idea, is that in certain cases you might find something that is much simpler, not expensive, done by people who are competent, and that the decision is obviously a decision that will be accepted. So this is the whole idea of access to justice, is something, an idea that is growing. We see this enormous amount of literature over the last 40, 50 years on the idea that all citizens have the right to access justice, although access to justice does not mean access in a court with a judge, a professional judge, but other forms of justice. So this is the first point question. And then there was another question. Padurario is asking, can the American judges be removed? No, they may not be removed. As a matter of fact, in the US, one of the distinctive features is that they are designated for life. For life. So you can go on while in continental Europe, they retire at a certain point, 70, they retire. In the US, they hold office for all their life unless they have misbehaved. Obviously, if they commit crimes and so on. Just to point out, we have two of the most distinguished law professors in the US, most distinguished. I'll write their name just so you keep them in mind. Richard Posner, the founder of the Law and Economics School in Chicago Law School, sitting on the Court of Appeal, District Court of the US, Second District, and and he's well in his 80s, and he's been designated, feels it a great honor to be, after having served for many years, for 40 years as a law professor, finishing his career as a judge on the Second District Federal Court. Guido Calabresi, Dean of the Yale Law School, one of the most, they always quarrel between Harvard and Yale, which is #1 in the US. For many years, Dean of the law faculty, Yale Law School, now has been sitting for over 20 years, if not more, on the First District Court of Appeal, Federal Court of Appeal. Well in his 80s, brilliant person, born in Ferrara, left Italy in '38, following fascist racial discrimination, went to the US and became one of the leading lawyers and law professors in the US. And you go on the internet and you find his speeches, and he's brilliant. And he's well in his 80s. I think he must be born in 33 or 1933, 35, something like that. So he's well in his 80s and still sitting, still doing judge. So they cannot be removed, and they are life. They can retire. See, they decide they are tired, they don't want to be. So this is a very strong independence in the US. Then now, American model of selection. Now, what happens is this: in the English system, the barristers select the best, those that are considered the most prominent lawyers, those barristers who have felt that sort of have better reputation among their colleagues, and they first become what is called QC, which is considered the sort of, when you are a lawyer, a barrister in England, and you are QC, you're sort of one step beneath the divinity. QC means, Queen's Counsel. So somehow could counsel the Queen in this case. But then among the Queen's Counsel, which is a limited amount, that's sort of very important, the most prominent barristers, among these, some will be selected as judges. So that is the English system. In the US, the system is significantly different. Because, why? Because American society is significantly different in respect of British society, which is pretty conservative, and the US instead is highly mobile. There's enormous social and geographical mobility in the US, where people change jobs quite a lot. While tradition, European tradition, is that you enter a profession and you go on with that profession for a long time. In the US, you will see that people who come out from the law school, maybe they'll start practicing law because they must repay their university, you should see this. And so they must make money to repay their tuition fees. But then when they move, they'll be practicing lawyers, then they might go to the turn for a few years, they may go in the federal government or the state government, and then they could move and they could become judges. So it is a very, very mobile society, also when it comes to the designation of judges. But let's focus on federal, because obviously we have 50 states, and I can't tell you from Alaska to Wyoming. It's difficult for me to give you indication. But let's look at a federal point of view. What happens is that you have circuit courts, which are sort of local courts, and then you have district courts, which are the Court of Appeal, and then the Supreme Court. So what happens? The president, according to Article 2 of the Constitution, designates federal judges, and these federal judges are generally chosen, indicated. Surely the bar suggests, the American Bar Association will suggest names of people that it feels are competent and that can be designated, but also from the public administration, people who are working in the government could be chosen as judges. They obviously must apply for this job, or they might come from the university. University professors might be designated as judges. So it is a much more fluid process. So we don't find only, in England you only find barristers that become Queen Counsel and then become judges. In the US you find they come generally from three different backgrounds: legal profession, government service, and university. So from these are three reservoirs from which judges in the US, federal judges, are selected. It rather depends, clearly it also depends on who the president is, and also on who is behind, who is counseling the sort of choice of judges. It is clearly the main issue of the Supreme Court, and we have seen that President Trump has been has played a very big role in changing the majority. Now it's a very steady Republican majority. 6 members of the Supreme Court are designated by Republican presidents, and only 3 by Democrat presidents. So that is the system through which they federal judges are designated in the US. But it's somehow different from the English system, because it's also decentralized. While in England it's still the High Court, the Court of Appeal, and the UK Supreme Court. They're all there in London, which is, there's very little decentralization. There might be some people that come from other parts of the country, but mostly everything is there in London. Now, let's see, Jubilee is asking, repeat the non-judicial fora. Now, traditionally, in our idea, at least the idea we've had from, let's say, from the 19th century onwards, when we have modern state, sort of where Prussia, Austrian Empire, Napoleonic France. We have the idea of the administration of justice as one of the expressions of the state. The state provides, obviously, has police, has army, has judicial order. And this belongs to the expression of the power of the state. Now, what happens gradually, what we find is that we try to have in order to satisfy certain requests for conflicts, when these conflicts become very significant, because clearly in the 19th century, most controversies were, well, there was criminal justice and civil justice, and that was main area of conflicts. Now we find with the increasing role of the state, with the increasing amount of legislation, well, we find an enormous amount of conflicts. And so how do we solve these conflicts? Can all these conflicts go in front of an ordinary judge? Just think of consumer. You have bought a product which is not selling. Ordered on Amazon a product, it arrives to you and it doesn't work. And you have a claim with the producer, say, yeah, this doesn't work, and the producer says, oh no, sorry, it actually worked perfectly well. You did not use it properly. And you spent, let's imagine, 22 euros for this product. Will you go to court for 22 euros? Nobody. So, I mean, you go to a lawyer will say, listen, I just warn you, but when you sit down here and tell me your case, well, you've already, those 22 euros, you already give them to me, much more than that. So nobody will, in his or her right senses, would bring this case to court. So but does this mean that any producer can produce defective products, knowing that anyhow nobody will bring a claim just because it is their petty claims like that? No, obviously not. So we cannot accept it. So we must find alternative fora in which these claims, which are legally grounded, you have defective product, but you must find some other place where to solve this conflict. So the whole idea is moving these things out of traditional court, which has its procedures, its traditions, its costs, moving them to places, to fora where this does not have the same, they're easy to solve and they're not expensive, because then this becomes, obviously the expense becomes the main barrier for which certain classes of people do not bring cases, because they say, well, I'm not going to spend all that money for these, for just to, I might lose my money for something that is worth very little from an economic point of view. So just to point out that we are increasingly, from one side, we want to deflate the pressure on the courts, reduce the number of cases that go to traditional courts. On the other side, we want to ensure access to justice. So this is now. Marikonda is asking, what are the main differences between English non-judicial foreign and peace judges? Now, just to point out, justices of the peace, whether in England or in Italy, are part of the judicial order. They are lay judges. That is, people who are not professional judges, generally people who are doing another profession. In England, quite often they are practicing lawyers. In Italy, they may be practicing lawyers, but they also may be people who are not practicing, who were practicing lawyers, and they are part of the judicial order, but they are laymen. When we talk of non-judicial, so this is part of the jurisdiction, and they will pronounce a decision which is a judicial decision, but it is taken by non-professional judges. When we're talking instead of non-judicial fora, we're talking of places where you decide cases which are not where the judges, quote unquote, are not professional. Not only they're not professional judges, but it's not a court. It doesn't have the same authority of a court. Let's take a typical conflict in the field of mobile, telecommunications. All of you have a mobile phone, whether you are in England or in Belgium or in Italy or in Europe. You have some kind of relationship with your telecom operator. This has to do, you might be pay as you consume, as you use your mobile, your telecommunication application, or you may have a flat rate. But just imagine that suddenly you have a flat rate, and for 1 month, your system, you have no internet connection because there's some problem that doesn't work. And you have paid, let's say, you're paying each month 25 euros or 50 euros for your high-speed connection, and this high-speed connection doesn't work. And so you say, I'm not going to pay this month because I did not have the connection. And so you have the kind of conflict, typical conflict between the user of the telecommunication services and telecom company. Just make an example. So what happens is that if there's this conflict, you see that the legislation, with all European legislation, whether European Union or not, establishes that these conflicts are going in front of somehow a mediation board, in which there's a board in which there's a member designated by consumer associations, a member designated by the Association of Telecommunication Companies, and then a third member who's the chairman, who is independent, and it must solve this kind of conflict. That's a typical non-judicial forum. There will be a decision that the parties will abide by. Clearly, if someone is not satisfied, that person may bring an appeal in front of the judicial of a court, and may bring the case in front of ordinary court. But traditionally, this will not happen because clearly, when the sum is very low, then or the company will pay, or the consumer will accept the decision and say, well, I've lost 50 euros, but will not go in front of the court. So just to point out that it's a non-judicial fora is we have, not only we do not have professional judges, but we do not follow all the rules of procedure, and it is somehow administered in a not in a court. While justice of peace is a very low-level court, but they are still part of the judicial order. Sorry, well, I hope I've answered my conda. And then, are there any more questions? Because if there are no more questions, I'm going to I have a whole lot of slides devoted to the money one pays to I would imagine that some of you are taking the law degree because they hope to make, if they don't have a family fortune, hope to make some kind of a living, a decent living through the legal profession. So it's also important to understand how much it can cost. I mean, access to justice, does it cost? Is it free, or is it expensive? So I think this is also an important point when we're looking at legal systems. It's not sort of only looking at very specific rules. We should look at also the rules, clearly procedural rules, but we should also look at economic, financial aspects of access to justice. Because if there are no more questions for this afternoon, I would stop here, because I think just let me see what the next slide is. Well, I would stop, if it's all right for you, I would stop here this afternoon, and then I would resume tomorrow with these aspects of financial aspects, and then going into the more technical procedural rules, because we are interested, obviously, in law school, we are interested in understanding what the importance of rules of procedure, very important when we look at jurisdiction. Jurisdiction needs rules of procedure. It is extremely procedural, and you win and lose cases on the basis of procedure. So if there are no more questions on this first part, I think today we can close our lesson here. Okay, then if there are no more questions, please, well, okay. Just please, those who sort of arrived after 4:05, can you please just write your name? Because I took most of the names, but I didn't manage to take all of them because you came, I started lesson at 5:05 and therefore sort of I didn't manage to write your names. So oh yes, Fiona Castro. I hear you talked about exam. I arrived too late to be able to hear all of I found on the 3 following dates, 3 June, 22nd June, are these. Quite right, you found the dates, and so sometimes I forget. Oh yes. Those dates, yes, those are the dates for Erasmus students because clearly, as this is for everybody, as you know, sort of government has decided to somehow soften the lockdown, but before we return to normality, it will take some time. So what I will be doing is and so Erasmus students, Locascio, Anzalone, Wood, Kidd, Albany, Monday, and Shiu, and I don't know if Hamilton is also in class, will be sort of taken, our Erasmus students will be taking one kind of exam, and I will indicate them procedures for the exam, while I still have to think of the way through which we shall organize our exam for our Italian students, our first year Italian students. This depends very much on what the decisions by the Roma Tre University will be. So I cannot give you the more detailed on the exam for our Italian students, but I hope as soon as the Roma Tre, the Senate and other academic bodies have established general guidelines on exams for the summer exams, then I will provide you with indications on how these exams will be held, because obviously the whole idea was that they would be held with your physical presence at the Roma Tre, but this, I have the impression, will not be possible. You'll see that, but I'm not able, as I told you last week, I'm not able to give you a precise reply. But anyhow, for Erasmus students, you can take note of those 3 dates, and I will provide you with indication on how the exam will be held, which is more or less how it was held in the previous years. But that is for only for Erasmus students who have a different program and are not first year students. So I hope this is sufficient for today. Okay.